I know a lot of people are fascinated by courtroom drama, and courtroom drama doesn't get much more dramatic than what happened here on the Central Coast. You might recall the high-profile court case earlier this year of the man accused of murdering Central Coast woman Liesl Smith. 23-year-old Liesl from Wallara was last seen on the 19th of August 2012. Her body was never found. But the Crown argued circumstantial evidence was enough to convict her ex-boyfriend James Church. The 51-year-old had pleaded not guilty, and in July, just a day before the verdict was due to be handed down by the New South Wales Supreme Court judge, Church committed suicide. And that forever locked up the decision. Now, Liesl's mum, Sandy Harvey, is campaigning for the legislation to be changed to allow for the verdict to be delivered if the accused suddenly dies. But what are the pros and cons of that? We have someone who was in the courtroom for all of those proceedings with us. Church was represented by local criminal lawyer Manny Conditsis. And Manny joins us this morning. Manny, good morning.
Good morning, Scott.
You spoke to Church the day before he died. What was your reaction to news of his death when you were about to learn his fate?
Like everybody else, Scott, I'd imagine one of complete shock. I did speak to him the evening before he took his life, and it's fair to say that he expressed that he was in a poor emotional state, but who wouldn't be when in a day or so he would be getting the verdict from the Supreme Court judge following a 4-month trial. So there was certainly nothing in that conversation that suggested he would do what he ended up doing. So complete shock.
And what happens now to the verdict? Where does it go?
All right, so the starting point, I think, is for the listeners to understand that according to law, in the context of a criminal case, when an accused person passes away, doesn't matter how, but when they are deceased, that brings an immediate end to the proceedings. So there are no proceedings on foot when an accused person has passed away. Whether that is the day before the judgment or during the trial doesn't matter. So, Her Honour, the judge in the Supreme Court, upon being satisfied that he had passed away, was not in a position to deliver a verdict, and she had her verdict. She was going to announce it the following day, the day following his passing. However, because the proceedings were at an end, legally there were no proceedings on foot. There were no proceedings for her to give a judgment in respect of. So she was, by law, restricted and not able to give a judgment as to the verdict, nor any other judgment in relation to the case as it unfolded over a period of 4 months.
And of course,
that is the legal position.
Yeah, and of course, Liesl's mother wants that law changed. What are the pros and cons of doing that? Where do you stand on that?
From a human perspective point of view, it is completely understandable that the loved ones and family of Liesl Smith would want to know the verdict. It is completely understandable that others in the community, including the family of the accused, may want to know the verdict. However, the problems, as I see it at least, are multiple, and they are these. Firstly, even though if a verdict was announced, and let's presume, just for the purpose of this discussion, that it was a guilty verdict. As a matter of law, if an accused person is alive and they are found guilty, that's not the end of the matter, because we know that an accused person can appeal. Similarly, even if the verdict was one of not guilty, the Crown can appeal. So what in the circumstance where the accused person, as here, has passed away, if the law was to be changed to allow the verdict to be published after their passing, then it would stand as whatever that verdict would be, hypothetically guilty. But how could there then be an appeal to determine whether that decision should stand because the person has passed away? On an appeal, a number of things could occur. The appeal could be dismissed and the verdict stand. Fair enough. On the other hand, the appeal could succeed and the appeal court, the Court of Criminal Appeal, could reverse the verdict.
Yeah.
And one further thing, another alternative is the Court of Criminal Appeal could order a new trial. These things could not be ventilated in the event that the accused person has passed away, even if the verdict was announced after his or her death.
Yeah, very problematic. It's a 7:45 ABC Central Coast. We're speaking with Manny Conditsis, a Central Coast criminal lawyer who defended Mr. Church in that case that's so controversial. He defended James Church, the ex-boyfriend of Liesl Smith, who was accused of her murder. Now, you presented evidence there, and there were witnesses for both the Crown and for the defence who corroborated evidence of another person of interest in the case, and that was something that the Crown also wanted released, because I believe the judge has to sum up on those other pieces of evidence that you present in defence to rule them in or out, sort of thing, because that could have possibly led to another line of inquiry. What happened there?
What I can say about that, Scott, is this, that the case against Mr. Church is what's called a circumstantial case. The defence in circumstantial cases would point to alternative scenarios, or what they would say, the defence would say, are alternative scenarios that would suggest that the accused did not commit the alleged crime. If the judge, as the judge of the fact and the law in this particular case, because it was a judge-alone trial, was satisfied that there was an alternative reasonable scenario, not the scenario alleged by the Crown, then the judge or the jury would be obliged to find the accused person not guilty. I can't go into too much detail, but what I can say is this. One of the alternative scenarios to which we pointed was that there was another individual who, over a period of years, had made a number of threats to Liesl Smith. And that particular person himself suicided in 2015. So,
and there was very strong evidence that person made these threats.
I don't think there was an issue in the trial that over the years this person made threats. It came from Crown witnesses who told the court about the threats that they heard made. And so one of the...
Can you mention where those threats were made? Because it was in a specific environment, or you can't actually go...
I can say that the threats were made in public settings, and it wasn't by just one or two individuals that heard it. It was numerous, and there was also evidence that on the defence case strongly suggested that there were some markings in a prison cell, and this particular individual spent some time making some disparaging remarks against her, which went hand in hand with the threats that others had heard. And so during the course of the trial, the defence pointed to this particular person. One of the, ultimately, considering her judgment, which we will not know what was in it, Her Honour would have had to delve into those particular allegations the defence were making against that particular person, and that would have unravelled in her judgment. That judgment, not only as to the verdict, but as to how Her Honour reasoned and got there, cannot, under the law, be disclosed.
But the Crown wanted that to be disclosed, didn't they?
They did.
Why did they want that disclosed?
The Crown conceded, after establishing the death of Mr. Church, that Her Honour was not in a position to provide her judgment as to the verdict. There was no issue about that. However, some days later, there was some positioning or posturing for potentially some aspects of the judgment to be disclosed, and as a matter of law, they couldn't be.
All right. Yeah. So I understand that evidence was rather strong that you gathered. Once again, circumstantial, but sadly, that's the way this has been tried. We approached the Attorney General's office. Mark Speakman says he's spoken with 2 members of Liesl Smith's family and has sought further advice from the Department of Community and Justice. He says the circumstances are very rare, but doesn't make the need to look at reform any less important. Your reaction there?
Indeed. And sorry, Scott, can I just say this, that any law that is made on the run, as I'm sure I've said to you on other occasions when we've spoken, invariably ends up being bad law. Making laws based on the outcome of one particular case, again, history proves, ends up being bad law. And for a whole multitude of reasons, some of which we've been able to go into this morning, others not, it would be a knee-jerk reaction to make a law based on this particular outcome.
All right. As someone who was there for every day of that trial defending Mr. Church, we understand you've got a lot more knowledge that you can share, but thanks for sharing as much as you can.
Thank you, Scott.
There's criminal lawyer Manny Conditsis, who was the defence lawyer for the man accused of Liesl Smith's murder. 23-year-old Liesl from Wallara was last seen on the 19th of August. Her body has never been found, and the Crown argued circumstantial evidence was enough to convict her ex-boyfriend James Church, who committed suicide in jail, as did that other person of interest named by the defence in the trial as well, who'd made death threats against Liesl Smith. Very distressing for a family. Manny Conditsis there. Lifeline is always there as well. 13 11 14 is the number if you need any help, if this story does stir up any problems for you.